The Supreme Court just dropped an 8-1 emergency order that is sending shockwaves through the legal community and fundamentally reshaping the strategy for Second Amendment advocacy in America. This isn't just another incremental ruling. This decision marks a massive shift in how the highest court in the land views the intersection of state sovereignty and your right to keep and bear arms. Before we go further, hit that subscribe button right now. We are tracking these cases in real time as they develop in 2026, and you cannot afford to be behind the curve on how these laws affect your local area. For years, the narrative has been that the Second Amendment is a 5-4 or 6-3 battleground, a partisan tug-of-war where gun rights live or die by a single vote. In District of Columbia v. Heller back in 2008, the landmark case that established an individual right to keep and bear arms, the vote was 5-4. In McDonald v. City of Chicago in 2010, which applied the Second Amendment to state governments, the vote was 5-4. Even the landmark Bruin decision in 2022, which established the text, history, and tradition test for gun regulations, was a 6-3 split. Second Amendment cases have always been closely divided. The conservative justices have consistently supported expansive gun rights. The liberal justices have consistently voted for more permissive gun regulations. That's been the pattern for over 15 years. But this 8-1 margin changes everything. What has legal experts stunned isn't just the lopsided score, it's the coalition. When you see Justice Ketanji Brown Jackson and Justice Elena Kagan, two of the court's most consistent skeptics of expansive gun rights, joining the majority, you know something seismic has happened. This tells you something extraordinary is happening, and it's not primarily about whether people have a right to own guns. This case involves a deeper constitutional principle that transcends the gun debate itself. To understand why this 8-1 vote is a genuine shockwave, we need to understand what actually happened. The case originated from Missouri's Second Amendment Preservation Act, a state law that prohibits state and local law enforcement from cooperating with federal enforcement of certain federal gun regulations that Missouri deems unconstitutional. The federal government challenged this law, arguing that states cannot nullify or refuse to help enforce federal law. The legal principle at the heart of this case is called the anti-commandeering doctrine. This is the constitutional principle established in cases like New York v. United States and Prince v. United States that holds that the federal government cannot compel state governments to enforce federal regulatory programs. The 10th Amendment reserves certain powers to the states, and one of those powers is the right to decline participation in federal enforcement schemes. The federal government cannot force states to use their own resources, their police, their databases, their money to enforce federal laws. Here's why this matters beyond just guns. The anti-commandeering doctrine protects state sovereignty across the political spectrum. It prevents the federal government from treating state officials as federal employees who can be commanded to carry out federal policy. This principle has been used to protect sanctuary cities that refuse to cooperate with federal immigration enforcement. It's been used to protect states that refuse to implement certain provisions of the Affordable Care Act. It's been applied across political lines for decades. What Missouri did with its Second Amendment Preservation Act was apply this anti-commandeering doctrine specifically to gun regulations. The state said its law enforcement officers would not assist federal agents in enforcing federal gun laws that Missouri believes violate the Second Amendment. The federal government's position was that Missouri's law went too far. They argued that while states cannot be forced to enforce federal law, Missouri's statute actively prohibited cooperation and penalized state officials who chose to assist federal agents. Lower federal courts sided with the federal government. A district court issued a preliminary injunction blocking enforcement of Missouri's law. The Eighth Circuit Court of Appeals upheld that injunction. Missouri then filed an emergency application with the Supreme Court asking the court to stay the injunction while the case proceeded. That's when the 8-1 order came down. The Supreme Court granted Missouri's request and stayed the lower court injunction. That means Missouri's Second Amendment Preservation Act can be enforced while the litigation continues. But more importantly, when the Supreme Court issues an emergency order, the justices are making a preliminary assessment of who is likely to win on the merits. An 8-1 vote suggests that 8 justices believe Missouri has a strong legal case. That's an extraordinary signal to lower courts about how this constitutional principle should be applied. Now here's what most legal commentators missed about the lone dissent. Justice Sonia Sotomayor was the sole dissenter. But she wasn't arguing that Missouri's law was unconstitutional. She was arguing procedurally that the case wasn't appropriate for emergency relief, that the normal litigation process should continue without Supreme Court intervention at this stage. Her dissent wasn't about the Second Amendment or even about the anti-commandeering doctrine itself. That means all 9 justices appear to recognize that anti-commandeering principles have some application here. They just disagreed about whether the Supreme Court should intervene right now or let the case develop further in lower courts. Why did the liberal justices sign on to this 8-1 majority? Because this order isn't just about the right to bear arms, it's about the right of states to say no to federal enforcement demands. By By joining the 8-1 majority, the liberal wing of the court is protecting a tool they know blue states need for other issues, like immigration or environmental law. The anti-commandeering doctrine is politically neutral. It protects state sovereignty regardless of which party controls the state government or which policy area is involved. But in signing on to protect this principle in the context of gun rights, they have handed Second Amendment advocates one of the most powerful constitutional shields they've had in 50 years. The Supreme Court is telling lower courts, this isn't a close constitutional question anymore. Federal overreach through commandeering has a limit, and that limit is the state line. The court's willingness to intervene with such a lopsided majority on behalf of a state law specifically designed to protect gun rights tells you something critical about how the court views Second Amendment issues now. The Supreme Court isn't just concerned with the substantive Second Amendment question of what gun regulations are constitutional. The court is also concerned with the structural question of how gun rights are protected against federal overreach at the state level. This 8-1 order isn't happening in a vacuum. It is the catalyst for a 27-state earthquake that will reshape federal gun law enforcement across America. Right now, more than half the country has either passed, introduced, or is actively defending Second Amendment preservation acts. Before this Supreme Court intervention, these laws were in legal limbo. Federal courts had been blocking them, and state officials were hesitant to fully enforce them, fearing massive federal lawsuits. But the Supreme Court just changed the calculation entirely. Let's look at the numbers, because this is where the implications become staggering. 12 states have fully enacted SAPA laws on the books: Missouri, Montana, Wyoming, Idaho, Arizona, Oklahoma, Kansas, Arkansas, Tennessee, Kentucky, West Virginia, and South Carolina. Another 8 states, including heavyweights like Texas and Florida, have SAPA legislation that has cleared major hurdles in their legislatures. On top of that, 7 more states have attorneys general who have issued formal legal opinions stating that their states can refuse to enforce federal gun laws they deem unconstitutional. That is 27 states. That covers approximately 157 million Americans, nearly half the population of the United States. Now consider the practical enforcement reality. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has approximately 5,000 total employees. Only about 2,500 of them are actual special agents who conduct investigations and make arrests out in the field. By contrast, there are over 700,000 state and local law enforcement officers in America. Federal agencies have always relied on state and local police as force multipliers. Imagine those 2,500 federal agents trying to enforce federal mandates in 27 states without a single phone call, a single backup officer, or a single shred of cooperation from state or local police. In the real world, the ATF relies on local police for everything: scene security, serving warrants, tactical backup, and investigative leads. When ATF wants to execute a search warrant, they coordinate with local police for backup. When they investigate illegal firearms trafficking, they depend on tips and intelligence from state law enforcement. When they trace crime guns, they access state databases and records. Remove that cooperation and federal gun law enforcement capacity drops dramatically. If 27 states pull that support, federal gun law enforcement doesn't just slow down, it effectively becomes a shadow of its former capacity. But there is a hidden financial dimension to this crisis that the Department of Justice fought desperately to prevent, and it's a number you won't see prominently in the news: $1.7 billion. That is the ATF's approximate annual budget. But here's the critical detail. Nearly 25% of that budget, or about $420 million, is funneled directly into grants and cooperative agreements with state and local agencies. These grants fund joint task forces, information sharing systems, training programs, shared databases, and overtime for local cops to help the feds. Missouri's SAPA law, and the framework now supported by the Supreme Court's 8-1 order, specifically prohibits state agencies from accepting federal money if it's tied to enforcing gun regulations the state deems unconstitutional. If this model spreads across all 27 SAPA-leaning states, the ATF could lose access to over $300 million in state-level cooperative funding. The feds aren't just losing manpower and backup, they are losing the very financial mechanism they use to incentivize cooperation in local police departments. The federal government's primary tool for encouraging state participation in federal enforcement programs becomes unusable in Preservation Act states. There is one more invisible tool the feds are losing, and it may be the most devastating: information. The ATF's National Tracing Center in West Virginia processes approximately 400,000 crime gun traces a year. But they don't do that work alone. They rely heavily on state-managed databases, concealed carry registries, state-level background check systems, and mental health adjudications that aren't always uploaded to federal files. SAPA laws are creating what can only be described as a database blackout. In Missouri, after SAPA implementation began, the ATF reportedly saw significant reductions in successful gun traces within the state. The guns didn't disappear. The feds just lost the ability to track them through state cooperation. If 27 states implement this database blackout model, the ATF could lose the ability to effectively trace a substantial portion of firearms annually. This represents a collapse of the federal investigative pipeline, and it leads directly to a crisis that federal prosecutors are trying to keep quiet: the prosecution collapse. Most people think federal gun cases are built from the ground up by federal agents working independently. That is largely a myth. In reality, approximately 62% of federal firearms prosecutions begin as local arrests. A city cop pulls someone over, finds an illegal weapon, and instead of charging them under state law, they call the ATF or the U.S. Attorney's Office to adopt the case federally. Why? Because federal sentences are typically harsher, and it creates better statistics for both agencies. SAPA laws, now backed by the Supreme Court's 8-to-1 endorsement of anti-commandeering principles, effectively shatter this referral pipeline. When a state prohibits its officers from cooperating with federal gun law enforcement, they cannot refer those cases to federal prosecutors. They cannot testify as the primary witness in a federal trial about evidence they collected under circumstances that involved potential federal violations. They cannot coordinate with the ATF during the initial investigation. Look at the data from the Western District of Missouri, the epicenter of this legal battle. Federal firearms prosecutions in that district have shown notable declines since Missouri's SAPA law was implemented. If this model goes national across all 27 SAPA-leaning states, we could see federal firearms prosecutions plummet significantly nationwide. The federal government would be forced to return to a pre-cooperative federalism model, only prosecuting cases that their own 2,500 agents investigate from start to finish. In a country of 330 million people, that level of proactive enforcement represents a fraction of previous capacity. This brings us to the most immediate practical victory for gun owners: enforcement of controversial ATF rules like the pistol brace rule. The ATF has estimated there are tens of millions of braced pistols in America. Their strategy for enforcement has always relied entirely on opportunistic encounters. They were never planning to proactively investigate 40 million gun owners. They were waiting for people to get pulled over by local cops, who would then check registration status or discover unregistered items. But in a SAPA state, that local cop is now legally barred from assisting the ATF with enforcement of regulations the state deems unconstitutional. They can't ask about your NFA paperwork. They can't report an unregistered brace. They can't help the ATF execute a search warrant based solely on a brace violation. By removing the 700,000-strong state and local force multiplier, this 8-to-1 ruling has effectively turned controversial federal gun regulations into dead-letter laws in half the country. They exist on paper, but they cannot be meaningfully enforced in practice. The same enforcement challenge applies to the National Firearms Act regulations on machine guns, short-barreled rifles, and suppressors. NFA enforcement has historically depended heavily on opportunistic encounters where state or local police discover unregistered NFA items during traffic stops or other routine law enforcement activities. If State Police and Preservation Act states cannot ask about federal registration status and cannot report unregistered items to federal agents, NFA enforcement in those states becomes exponentially more difficult. Or consider the Gun Control Act's prohibitions on certain categories of people possessing firearms. Convicted felons, domestic abusers, and people adjudicated mentally ill are prohibited from possessing guns under federal law. But enforcement of these prohibitions typically happens when state police encounter someone during a traffic stop or domestic call, discover they have a gun, run their background, and find they're a prohibited person. The state arrests them, and then federal prosecutors can adopt the case for federal prosecution with harsher sentencing guidelines. Cut off that referral pipeline in SAPA states, and federal enforcement of prohibited person laws depends entirely on federal agents independently discovering violations. That's a dramatically smaller universe of cases. As we head into 2026 and beyond, the long-term constitutional implications of this 8-to-1 order extend far beyond the Second Amendment. This isn't just a win for gun rights advocates, it's a precedent that will be cited in cases having nothing to do with guns for decades to come. The anti-commandeering doctrine is politically neutral, and that's what makes this 8-1 vote so consequential for American federalism broadly. Consider how Democratic-controlled states have already used anti-commandeering principles in recent years. When previous federal administrations tried to pressure sanctuary cities into cooperating with federal immigration enforcement, those cities cited anti-commandeering doctrine. They argued successfully in many cases that the federal government cannot compel local police to detain individuals for immigration violations or share information with federal immigration authorities. The legal reasoning sanctuary cities used is functionally identical to the reasoning Missouri is using for its Second Amendment Preservation Act. Now imagine how this framework expands with an 8-to-1 Supreme Court endorsement. Republican-controlled states could refuse to help enforce federal environmental regulations on energy production. They could decline cooperation with federal agencies implementing climate-related policies. They could prohibit state officials from assisting with federal healthcare mandates or education regulations they view as federal overreach. Democratic-controlled states could refuse cooperation with future federal policies on reproductive rights, voting regulations, or labor law. They could decline to share state databases with federal agencies enforcing policies the state opposes. The Supreme Court's 8-1 endorsement of anti-commandeering principles in this case gives both political sides a constitutional shield against federal policies they fundamentally disagree with, and because the vote was 8-1, with justices across the ideological spectrum joining the majority, this precedent has unusual durability. It's not a narrowly partisan decision that can be easily revisited when the court's composition changes. For decades, the federal government has operated on an assumption of cooperative federalism. The model has been that even when states disagree with federal policy, they generally maintain basic cooperation with federal law enforcement and regulatory agencies. Information gets shared. Databases remain accessible. State police don't actively obstruct federal operations even if they don't enthusiastically support them. That assumption is breaking down, and this Supreme Court order dramatically accelerates the breakdown. Once states realize they have robust constitutional protection to decline cooperation, and once they see that protection endorsed by an 8-1 Supreme Court vote, the political incentives shift fundamentally. State legislators who want to signal opposition to federal policies now have a constitutionally protected mechanism to do so. They can pass preservation acts or non-cooperation laws, knowing the Supreme Court has indicated these laws are likely constitutional. Governors can direct their agencies to minimize cooperation with federal enforcement without fear of federal legal retaliation. The federal government's traditional tools for compelling state cooperation have been funding conditions and legal threats, but anti-commandeering doctrine limits both of those mechanisms. The Supreme Court has held that funding conditions must be genuinely related to the federal interest and cannot be coercive. If states can refuse federal grant money without being penalized, funding conditions lose much of their leverage. Legal threats are similarly constrained. The federal government cannot sue states to force them to enforce federal law. That's the fundamental principle of anti-commandeering doctrine. This creates a future where federal agencies face dramatically varying enforcement capacity by state, and they have constitutionally limited tools to change that reality. Some states will maintain full cooperation. Other states will minimize cooperation to the greatest extent constitutional doctrine allows. Federal agencies will have to adapt to this patchwork landscape with the limited resources they have. Here's the uncomfortable question that makes both political sides hesitate. If states can decline to enforce federal gun laws they deem unconstitutional, can states also decline to enforce other federal laws they deem unconstitutional? And who decides what's unconstitutional? The traditional answer has been that federal courts decide what's constitutional, and states must comply with federal court rulings even when they disagree. But Second Amendment preservation acts introduce a more complex dynamic. They allow states to make their own constitutional judgments and act on those judgments by refusing cooperation with federal enforcement. Missouri's law doesn't say the state will refuse to cooperate with federal gun regulations that have been declared unconstitutional by federal courts. It says Missouri will refuse to cooperate with federal gun regulations that Missouri deems unconstitutional based on Missouri's reading of the Second Amendment. If that principle receives full Supreme Court validation, and an 8-1 emergency order strongly suggests it might, then states have significantly more autonomy to resist federal law than previously understood. This emergency order is just the beginning of this case, not the end. The underlying litigation will continue in lower courts, and eventually the Supreme Court may take the case for full review and issue a comprehensive opinion addressing all the constitutional questions involved. But an 8-1 emergency order gives strong indication of how the court is likely to rule when that day comes. For gun owners, this decision means states have powerful constitutional tools to resist federal gun regulations they view as unconstitutional. For advocates of state sovereignty across the political spectrum, this decision reinforces anti-commandeering doctrine as a meaningful and enforceable constraint on federal power. For federal agencies, this decision signals that their traditional reliance on state cooperation can no longer be taken for granted as an automatic feature of the federal system. The Supreme Court has issued an order that could permanently reshape the balance of power between federal and state governments on Second Amendment issues and far beyond. Whether you view that outcome as protecting liberty or undermining necessary federal law enforcement depends on your broader constitutional philosophy about federalism and the proper structure of government power in America. But one conclusion is undeniable. The 8-1 vote means this isn't a close constitutional question in the minds of the justices. The anti-commandeering doctrine is alive, robustly applicable to Second Amendment preservation cases, and likely to be a defining feature of federal-state relations for the foreseeable future. And that changes everything about how gun rights federalism works in America going forward. If you want to stay informed as this case develops through the courts and understand how it affects gun rights and federal-state relations nationwide, subscribe right now and turn on notifications. Drop a comment telling me whether you think states should have the constitutional power to decline cooperation with federal gun law enforcement, and what you think the long-term implications will be for federalism in America. This is just the beginning of a constitutional transformation that will unfold over years, and I'll be covering every major development.